To Thursday Talks with Chugh. Each week we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chugh, attorneys and CPAs tuning in from our San Diego office. Please join me in welcoming attorney Maureen Scorese from our Edison, New Jersey office. Hi there, Maureen, and welcome.
Hi, Arianna.
Thank you so much for being here. For today's topic, we will be talking about discrimination in the workplace, knowing your rights and responsibilities. Just a quick disclaimer before we get started, this conversation is for informational purposes only. It does not create an attorney-client relationship, so if you do have any questions, please comment them below or email us anytime at info@chugh.com. So let's start with the basics, Maureen. How is workplace discrimination legally defined?
Workplace discrimination is generally based on certain protected characteristics, and you would look to those definitions for each of those. So some of the common protected characteristics include race, color, religion, sex, national origin, and age, as well as disability. And some places are more specific and can include, depending on state laws, including genetic information, marital status, or political affiliation.
Understood. So what laws apply to workplace discrimination?
So there's both federal and state laws that apply to the workplace discrimination. The federal laws that are most common are Title VII under the Civil Rights Act of 1964. You also have the ADEA, which is the Age Discrimination and Employment Act, the ADA, the American with Disabilities Act, the Genetic Information Non-Discrimination Act, as well as the FLSA, which governs equal pay. And the Equal Pay Act was another law passed that was an amendment to the original FLSA. And then the state laws that you would have to look at each state. Some of the state laws would similarly apply, follow the federal laws, but also have additional requirements.
Okay, so quite a few laws. What are the key federally protected classes, and how do state laws expand on those protections?
So the classes of protection are those that I mentioned earlier, those that fall into one of the protected characteristics, right? Race, color, religion, sex, which can include also gender identity and expression, the national origin, the age, disability, and genetic information, marital status, or political affiliation. So those were generally, and the laws that I mentioned earlier would apply for those.
Okay, I'm curious, are there types of discrimination that are commonly overlooked, like maybe unconscious bias or appearance-based bias?
So absolutely, that's a really good question. There has been a lot of discussion of unconscious bias it's for several years now. And so that is definitely unconscious or implicit bias, which can just occur, it can affect our understanding of stereotypes. And simple attitudes that impact actions and decisions that are not always conscious. And so also it can lead to unfair treatment for individuals and resulting in discrimination. And then there's also indirect discrimination that can occur when there's not an explicit intent of a policy, but it can indirectly discriminate, and that can happen as well. So then the other thing about appearance that you mentioned would definitely apply. Sometimes there's weight discrimination that is not always apparent. But that can happen. There are studies that have been shown that people who have larger bodies can face lower salaries, fewer promotions, or other types of bias in the workplace. So these are other types of discrimination that can be overlooked and also contribute to mental health issues.
Really interesting points there. So, how do harassment and discrimination differ under the law?
So as we discussed earlier, we defined discrimination. The harassment is a way in which discrimination may manifest itself. So it's harassment is usually defined by a state's criminal laws, and it involves a pattern of behavior that creates a hostile, intimidating, or offensive environment, Harassment can be verbal, physical, or visual, such as someone posting, offensive pictures by their desk. It can include jokes that might be shared in an informal setting, such as a lunchroom, or unwanted sexual advances in some circumstances. And so the harassment does not always mean discrimination, but it can sometimes be a form of how discrimination manifests itself in the workplace to create a hostile environment.
Mm. Can you explain the difference between direct discrimination and disparate impact?
Okay, so direct discrimination is what we've talked about. It would be more obvious and it occurs when someone's treated unfairly because of their protected characteristic, whether that be age, race, gender, or and it would appear that that person is being treated worse than others are treated because of that protected characteristic. Um, Disparate impact really refers to employment practices that appear to be neutral. When you first look at them and on their surface, they would be neutral. But in their implementation, they actually result in a disproportionate disadvantage to a protected group. Um, and so it's not always obvious, but it does occur in an indirect way.
Okay, I want to talk a little bit about compliance in the workplace. What are employers legally required to do to prevent discrimination in the workplace?
So the employers need to comply with the law on all levels. So they need to be informed of the anti-discrimination laws that would apply to them. There can be local, state, and federal laws. We mentioned the federal laws already. We did not go into detail on the state laws, but it does vary. So if you're only in a few states, it would be worthwhile to check on those laws to see what applies to your environment, your workplace. The other thing too, as far as legal compliance would be um, to prohibit, one of the things obviously would be to prohibit discrimination in your policies, in your employment handbook or policies that you might periodically publish, to have a program and policies in place for prohibiting discrimination and also to foster a culture of respect. So an
Mm.
employer, one more thing, they can just provide reasonable accommodations for people with disabilities, and they can review their employment practices periodically to ensure that they're compliant because the laws do change. There's amendments, there's additional regulations that might be passed by different agencies, and new laws are enacted all the time, including pay transparency. Laws are increasing as well, just by way of an example. And so all of those things help to prevent discrimination in all the different ways that it could arise.
Mm. To go a little bit deeper into that, what makes an anti-discrimination policy not just compliant, but actually effective?
So that's a good question. And so a compliant policy is one that really meets the minimum requirements of the law. Whereas an effective policy is one that takes it a step further and it complies with the law, but it also actively prevents discrimination from happening. So it might have a little bit more meat and substance to it to ensure that the workplace culture is one surrounding tolerance and addressing discrimination in a proactive way, and really trying to prevent it.
Mm. Great points there. So, how should employers ensure fairness in the hiring process, promotions, terminations, through all of that?
Okay, so first and foremost, they should have clear policies and procedures that address anti-discrimination, right? And their prohibition against it. The other key point is to train your personnel. You should have different types of training for people that are in management positions or hiring positions so that they have that nuanced training to address the circumstances that they face that others in non-management positions would face. So you should definitely train your personnel on all levels at the appropriate to address what they'll be encountering in their positions. You would also want to conduct refresher training, perhaps annually, for all personnel. And if there is an incident that occurs, you would then want to do a refresher training and at that time, like shortly after an incident might be reported. Another thing that would really be helpful is to have your managers and supervisors have an open door policy with their staff. So to just reiterate that sometimes, or always try to be open to listening to reports and constructive input from your personnel so that you have a streamlined open communication. So in that way, the supervisors can hear if there is any conduct that could approach the level of discrimination or be discriminatory and respond to it appropriately.
Hmm. So, what risks do companies face if a client or vendor or maybe a contractor discriminates against one of their employees? How should they handle that?
So it's important for employers to know that they're responsible for providing a non-discriminatory workplace. And that includes guests that come on the premises. That includes partnerships you have with vendors or other contractors or consultants. So that employer, even though they're third parties, the employer is still overall responsible for the non-discriminatory workplace. And in that case, then the employer needs to, there's a lot the employer can do in those circumstances to try to control the situation, including their contracts to have the requirement for vendors to have also match or meet, at least meet or exceed the requirements of the employer and what they have in their policies. So they can have independent contractors sign off and agree to adhere to the employer's policies against discrimination. In situations where the employer would have a reasonable basis to know about the discrimination or the discriminatory conduct, they should then investigate promptly. They should take steps to respond. And they can also, handle it in different ways through open communication with also those third parties.
So you mentioned anti-discrimination training and especially for different roles like people in management, things like that. So how often would you say anti-discrimination training should be conducted and how can it be tailored for those different roles?
So I addressed some of this earlier, but I could definitely at least annually, you want to have training. Just as a refresher, you should have training completed on hiring when somebody is new. So you would do definitely have training of personnel as they are hired, refreshers at least annually. If there's a change in the law, you may also want to do training on that, depending on what aspect has been changed, right? And who it applies to. And then you also want to have the training done right after an incident has occurred, just as a refresher course. And again, you would have this tailored to the specific role of the staff that you're training, whether they be supervisors or mid-level managers or non-managers as well.
Understood. So I want to get into the employee side of things for a little bit. What should an employee do if they believe they're being discriminated against?
So I would hopefully they have a good employer where they have that open door policy. They should report it to their supervisor. They should bring it up to that person who would then have the training to know how to handle it.
So, what protections would you say exist to ensure employees aren't retaliated against for speaking up? I'm sure this is something that a lot of them might worry about.
Mhm. For sure. And so there are whistleblower laws to protect them. There's also laws that include anti-retaliation provisions so that if there is, I know New Jersey has that as well. in their laws. That I'm based in New Jersey. So those federal and state laws would protect the employees for speaking up. And I did want to go back to that prior question. If they feel that they can't go in-house, if they feel that the employer is not addressing it, they can also seek advice from an attorney. If they're worried about bringing it up at the workplace, it might sometimes make them more comfortable to reach out and get advice from an attorney before even reporting it at work, depending on, their comfort level and what they experienced.
Yeah, great points there. So let's say internal reporting doesn't work. What would the next steps be, especially with the EEOC or maybe some state agencies? What would you suggest?
Okay, so oftentimes there are agencies in the state. The Attorney General's office will have a division of civil rights. So you can go to either to file your report. It's something that you can find on any state's government website for the Attorney General on how to submit a complaint. Oftentimes, if you submit a complaint with the state division of civil rights, they may already be connected with the EEOC, and that complaint will be automatically submitted with both organizations. And so those are the options. You can also file a separate lawsuit um, with the state or federal court as well. It may depend. You may have to check, and this is where an attorney could come in handy. Sometimes you do have to go through the agency before you can go to court to file your lawsuit, but oftentimes it's up to the plaintiff to choose their path as far as how they want to proceed.
Understood. And what's the timeline and process for a formal complaint or legal claim?
So if you're going to the EEOC and the state agencies as well, there's oftentimes a limitation where you must file a complaint within a certain amount of time. At the EEOC, it does have to be within 180 days of the event, the discriminatory action. Um, and the resolution for that, the processing time, there's an investigation and then the decision, that can take up to a year or two. Um, at the EEOC, agencies are often a year and a half, although they want to make, I know that there's statements that have been published by some state agencies that they try to do it expeditiously, but depending on the people involved and the complexity of the incident, that investigation can take some time. So normally a year or two. If you end up going into court and litigation, that can take several years. Definitely 2 years, I would say. But it really, again, will depend on the court as well as the complexity of the case, the number of witnesses involved.
Absolutely. So, can individual employees be held personally liable for discriminatory behavior?
They can actually, they can be held liable personally. Yes.
Wow, okay. Can you talk a little bit about how the recent executive orders have impacted the workplace?
Sure. So those executive orders that were issued relating to discrimination and DEI initiatives really impact the federal workplace more, federal contractors and recipients of federal grants. It definitely impacts those parties more so than private employers. I do know that some state attorney generals have reiterated that their state laws still apply and not those particular states would consider that the executive orders don't limit the state laws or impact the state laws and their enforceability. So it creates a little bit of a conundrum for some organizations because of the apparent contrast with what those executive orders want to address, but what the state laws and the federal laws too would still be expected to be enforced in certain states.
So, beyond compliance, how can companies foster a culture that actively prevents discrimination?
So Good policies first and foremost. Having clear policies that are easy to understand that prohibit discrimination. And also just annual training. We'll do it, annual training and reminders on those policies. And honestly, team building is great for everyone. It makes, I think, working together better. And it's another way to indirectly prevent discrimination by just building your team and its cohesiveness and working together.
Absolutely wonderful insights. I have one more question for you, Maureen. How can a firm like Chugh support companies in staying compliant and addressing potential discrimination claims?
So the compliance matter, a firm like Chugh can help the companies by figuring out where their operations are based, where their employees are based, and make sure that as laws change or laws are enacted, that they stay informed of that. It's always good to have annual meetings with your attorneys to just ask those questions, maybe have them review the laws as they might have changed. Review how your company has changed. What if your company has expanded into a new line of business? And how is that going to impact the workplace environment and your prohibition against discrimination? What state laws might be new? Have you expanded into a couple new states? And do they have more stringent state laws than the federal laws that you weren't aware of? I always recommend for our corporate clients that they sit down with us at least once a year to just kind of review those things, right? Changes in the law, changes in your business. So that's one way we can help. And we tailor it to those companies and where they're operating. And then also, as far as addressing potential discrimination claims in a proactive manner, it's good you can sit down with your clients and ask them if they are receiving feedback from their employees. It might make sense to poll your employees periodically for concerns or for their feedback on how trainings are going, how the workplace is. And so there's ways that we could sit down with that company, hear if there's been any problems that have arisen with the workforce or staffing issues, and maybe identify some potential areas of where discrimination claims could arise to then help them foster policies and training to prevent that.
Wow, what an important conversation we've had today. Thank you so much, Maureen, for all of those insights. That is all we have time for today. So this brings us to the end of our conversation. Thank you, everyone, for joining us. A special thank you to you, Maureen, for taking the time. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. If you have any questions or suggestions, send us an email anytime at info@chugh.com. We would love to help you out. Let us know what topic you want to see next. And make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care, everyone. Thank you again.
Thank you.